This podcast explains how freedom of information and other information access tools can be used to counter or defend against a strategic lawsuit against public participation. It will begin by providing a general overview of how freedom of information or FOI laws work. And because the procedure for making and responding to FOI requests is something that's jurisdiction specific, this discussion will be at a level of generality. You're going to need to consult your own jurisdiction's FOI laws for the specific provisions, but I will be providing some examples to illustrate as I go along. I will then turn to subject access requests, which allow individuals to find out what personal information an organization is holding about them. As data protection and freedom of information are like two sides of the same coin, so it's very useful to know when each can be used. And as an umbrella term, I often use the phrase information laws to refer to FOI and similar transparency laws, as well as data protection law. And finally, I will consider how FOI and other information laws can be used to defend against strategic lawsuits against public participation. Freedom of information laws confer a legally enforceable right to information held by public authorities, including central and local government bodies and police forces. Most FOI laws only apply to public bodies, although in some jurisdictions they can extend to private entities that perform functions of a public nature, at least in respect of those functions. So for example, Scotland's freedom of information law was extended a few years ago to apply to privately managed prisons. Public access to official information is increasingly recognized as an essential feature of democratic societies due to its role in supporting the transparency and accountability of institutions, reducing corruption, and enhancing public participation in democratic governance. Legal scholar Carol Harlow has called freedom of information the most fundamental of our civil and political rights, and it can be used to support other fundamental rights, such as the right to freedom of expression. So freedom of information laws have expanded rapidly over the past 30 years or so. In 1990, only 13 countries had FOI laws in place. By 2005, this number had jumped to approximately 66. And now the number of countries has almost doubled again. The last time I checked, which was very recently as I was preparing this slide, but the last time I checked, 128 countries have now enacted freedom of information or other similar transparency laws. And these laws are, of course, highly variable in terms of their scope and the specific procedures therein. But the common theme is that the public have a right to know how governments and other public institutions are performing, and FOI is the tool that can be used to obtain that information. FOI laws can be used to obtain a wide variety of information. Again, the details will vary by jurisdiction, but generally, FOI laws apply to a wide range of recorded information. This includes official documents, as well as drafts, emails, memos, meeting agendas, and statistical data sets. FOI has been used to force high-profile disclosures of information, such as information on MPs' expenses here in the UK, or the correspondence between Prince Charles, as he was then, and UK ministers. So these are the types of disclosures that make the headlines, But there are many more everyday uses of the Freedom of Information Act. And this includes the disclosure of planning applications, local authority meeting minutes, or council budget information, to give just a few examples. Most jurisdictions will have an information commissioner or another similar body responsible for enforcing FOI legislation, and their websites will usually provide more details on which types of information can and cannot be obtained under FOI. Generally speaking, to make an information request, one will need to make a written request to the organization that holds the information. Now, it's very useful at this stage to be as specific as possible. Whilst it might seem like a good idea to make a broad request in the hopes of receiving sufficient information, narrowing your request will help to minimize the risk of having an exemption applied or a request denied altogether because it would take too much staff time to respond to. And I'll say more about exemptions in just a moment. Once the request has been made, the information holder will then have a limited period of time to respond to the request. They will confirm whether the information is held and will disclose the information where possible. However, if the information cannot be disclosed, either in part or in full, then they will need to specify which exemption or exception to disclosure applies in that instance. And they might also respond to the requester to say that they cannot fulfill the request because it's too broad and that responding to it will take too much staff time to complete. They might suggest at that point that you narrow the request, but that could also reset the clock so that the time limit is then applied again from when you make the second narrower request. And so therefore, when you're making an information request that is time critical, as will often be the case, it's very important to do as much as you can to allow that request to be filled quickly in the first instance. Now, if you do not receive a request within a specified time limit, or you believe that the information has been unlawfully withheld, then you can follow the complaints process available in your jurisdiction. Often, this will involve making an internal complaint in the first instance to see if the matter can be resolved internally. Now, once that avenue is exhausted, there will be an external complaints procedure. This could include complaining to the Information Commissioner or another independent ombudsman service with responsibility for investigating FOI complaints. And as I mentioned earlier, FOI laws typically apply to public authorities, and therefore they will usually not apply to private entities unless the law extends to private bodies carrying out public functions. For example, privatized or outsourced public services. And most FOI laws will also include specific exemptions for personal information or data. This is, of course, protected under data protection laws. And this is a frequently engaged exemption, and information requests are likely to be denied, at least in part, when the information request involves third-party personal data. Other exemptions can include national security and defense, information provided in confidence, and information relating to commercial interests. And when making an information request, it's very useful to consider the range of exemptions that apply and how those might be engaged, and whether it's possible to narrow the request at the initial stage to help ensure the timely disclosure of relevant information. And subject access requests give individuals the right to find out whether an organization is using or storing their personal data. This helps individuals to understand why information about them is being held, and it allows them to check that the information is being used lawfully. This includes the right to request personal information from the police or from social work services, to give just a couple of examples. And as I'm sure you know, the EU General Data Protection Regulation imposes obligations on organizations that collect or store information on individuals living in the EU. Article 15 of the GDPR protects the right of access by data subjects to obtain information from data controllers, including the right to request erasure of personal data and the right to lodge a complaint with a supervisory authority. So FOI laws and other information access tools can be used to obtain information to defend against SLAPPs. For example, subject access requests give individuals the right to find out whether an organization is storing or using their personal data. This information can be very useful if your client believes that they are subject to a meritless or vexatious investigation. Now bear in mind, the information that they can obtain about live investigations will be minimal, but it can be useful to have a general understanding of what information is held about a person. As another example, a journalist can make an FOI request to obtain information to demonstrate the truth of a story that they have published or that they plan to publish. So in this way, the information obtained through the FOI requests is sort of like a form of evidence that can corroborate their story. But on the other hand, it is important to consider when information laws can be used to stifle the public interest or even to initiate a strategic lawsuit against public participation. For example, I recently read a story about a Hungarian corporation that had complained that a magazine investigating its activities and its link to the Hungarian government had processed personal data without a legal basis, and that, of course, was contrary to the GDPR. And this corporation succeeded in having the magazine story pulled on this basis. So FOI and data protection laws, we can see that they are powerful tools in defending against SLAPPs, but they can also be used by the opposition to stifle the public interest. And this is why it's very important that anyone subject to information laws, including domestic freedom of information legislation and the GDPR, should ensure that they have full knowledge of the laws and the compliance requirements.